Hi, welcome to the Marcus Williams Training Academy Professional Misconduct Response Program. Today, we are going to go through lesson number 6, Concurrent Law Enforcement Involvement. So we are going to talk about what happens when there is a criminal case that is happening concurrently with your administrative misconduct case. So my name is Marcus Williams, and I am the president and founder of the Marcus Williams Training Academy. I was in law enforcement. I was as a police officer at the Pentagon and then a special agent with NCIS for almost 17 years, 16, 17 years. So I had the experience of working investigations from that side, criminal investigations under the color of law with the authority and jurisdiction backed by statutes. I was also an investigator at Brigham Young University for all of their sexual misconduct cases under Title IX involving students. And in that capacity, I was doing administrative misconduct investigations. And very often, those cases had a concurrent law enforcement investigation happening. So I have seen both sides of the coin. I have been on both sides. There are pros and cons to each. There are benefits and there are drawbacks. There's differences in authority and capability. And the takeaway that I want you to have in this lesson is that you can be successful doing an administrative investigation, even if you don't have all of the authority and tools that a law enforcement agency has, you can still be successful. And I found that very much to be true as I worked the administrative cases and as I have continued with the consulting group and helping companies with administrative investigations. So LE, or law enforcement, there are times when you are going to receive an allegation or receive information that you need to report to law enforcement. Some things are mandatory by statute. So child exploitation, child pornography, pretty much in every state, I believe, that's mandatory. Check with your legal. You probably already have a program in place through your general counsel's office on how to report that because it is a statute, or your human resources office. But you need to be aware of that. So if you get that type of report where your IT department comes to you and says, hey, one of our employees, we just found them browsing child pornography on a work computer or on the work network, obviously you're going to start an internal misconduct investigation, but that legally has to be reported to law enforcement. And the reporting methods, the reporting requirements vary by state. Some states it has to be directly to a law enforcement body. Other states it can be to your child and family services or child protective services, whatever it's called in your state. So you need to make that report and make sure that you get a name and report number so that you can document that you've made that report. It may be wise to designate one person as your reporter so it's easier to track and you know if it's been done. If you don't have a designated reporter, everyone might think that the other person filed the report and then it never gets done. But if the buck stops at one person, then you can ensure that you are in compliance with the law and you get those reports done. And those are very important to help protect, but designed to help to protect children who can't protect themselves. And so we want to get state agencies and resources activated and working and in place as quickly as possible. And you may look at child pornography a little bit differently because those are images on the web. So you may not think of it as a child, like it's different than an employee abusing their own child. But think of it this way, those are images of a child being abused. So there is a child out there somewhere who is being abused and those abuse images are being shared. Some of them law enforcement they already know about, they've already handled, others they haven't, but you don't know that, that's not your job, so file the report. There are other cases that may not be mandatory, and you may have to decide whether you want law enforcement to be involved, whether you want to report them to law enforcement. When it involves some sort of theft or fraud, you may have to decide as a company, do we want to go through this? It will become public. Is it worth it? Is the loss large enough that we need to pursue these charges? Different people have different opinions about the legal system and the justice system. That's up to you. That should be a decision that you make with your senior leadership and your legal counsel. But on cases that are not mandatory, you have to decide whether or not you are going to report to law enforcement. So when you're making that decision, think outside of just your own box, your own organization. Is there a wider impact to this behavior? Are there other individuals or other companies that have been impacted by this misconduct that maybe you need to allow them to have a say in the decision-making process? Maybe this behavior has crossed state lines or international boundaries through network intrusions or hacking. So in those cases, it may be in your best interest or the best interest of kind of society at large that you report them and that they are handled or investigated through law enforcement. Law enforcement also has information that you don't. So there may be patterns. So if you have someone who has hacked into your system and you think it's a one-time thing, so you lock it down, you figure out where the hole was and you patch it and you think you're good. Well, you don't know if several other companies in your industry or in your area have also gone through the same thing. So if law enforcement may have information, they may have open cases that are related to your case that you don't know about. And so by reporting it to them, you're giving them more information, you're giving them more evidence. You may have the key to the investigation that helps them solve or complete the case. And you don't know that up front. So take that into consideration when you are making that decision. When they are personal crimes, in other words, one employee against another. So say in the case of a sexual assault where one employee assaults another, it happened, in this example, it happened on company property. So you do have an interest in it, obviously. This is clearly an allegation of employee misconduct, but is it really your place to decide whether or not law enforcement should be involved? Look at your policy. How is it written there? Do you allow the impacted party, the complainant or victim in the case, to make that decision? Or are you going to force a report to law enforcement? I think the cases will, and through my experience, I've found that cases will be much more effective if the person impacted, the victim or the complainant, actually wants to make the report to law enforcement. They're much more likely to be engaged and involved in the process if they wanted that process in the first place. So there are a lot of states now in sexual assaults where a victim can go to the hospital, get checked out, have a sexual assault examination, forensic examination take place. Law enforcement is called to document it and seize that kit, the forensic examination kit, but then the victim still has the right to decide whether or not they want an investigation. So even when all of that stuff has happened and law enforcement knows about it, many states have gone to a model where they still allow the victim the right to decide whether or not they want to pursue the case. And the great thing about that model is that the state or law enforcement is able to collect evidence from that kit before it's lost, so in a timely manner. The victim gets medical attention without fear of being forced into a process they don't want, but then they still get to make that decision. So that model is being used even by law enforcement, and it should be a model that you also emulate, where you are giving them the choice. Provide information on what that means. Go out and talk to your local law enforcement and ask them for brochures or pamphlets or information so that you can share that with your impacted employee. You're not trying to influence them. You're not trying to influence their decision, but you are allowing them to make an informed decision because you have information that you are providing. And if you live in a state where they can talk to someone, say a victim advocate at the police department, they can talk to that person without having to pursue a case, know that, inform them of that so that they know that they have that option. So I would highly recommend considering allowing, in personal crimes or misconduct, allowing the impacted party to make the decision. Include all of this in your policy. So if you are going to allow people to decide, then put that in your policy. Because you may be personally of the opinion that every case needs to be, these cases are much more appropriately handled by law enforcement. They're criminal cases and crimes need to be reported. You may be very black and white about that. Or you may have a negative opinion regarding law enforcement. You can't allow that, your bias regarding law enforcement, to influence someone else's decision. If you put in your policy that you are going to allow them to decide, then you need to follow it. And you've heard that over previous lessons. A policy is ineffective. It doesn't do anything if you don't follow it. So make sure that when you write it in the policy that everyone understands that and follows it. It's okay to build in a safety exception or a risk exception. So a lot of states, in fact, most states, have mandatory arrest laws for domestic violence, because it is so difficult for a victim of domestic violence to press charges, because often that leads to further violence. But when you take that decision out of their hands and it's a mandatory thing, the hope is that will reduce the risk to them personally. Whether that's true or not depends on the case. But if you build in a safety exception where someone is saying, no, I really don't want to, but you see that there's truly a threat, a safety risk involved here that is beyond your capacity, you do not want to be the organization that didn't respond, that didn't take action when there was a risk, and then something even worse happens. So if you say it's a stalking case and you feel like the stalker is dangerous, there have been threats made, but your complainant is minimizing it, thinks that by reporting it, it'll get worse. And so you honor that and don't do anything, even though you truly feel that it is a safety issue. And then later that stalker comes in and engages in some sort of violence. That's not a position you want to be in personally or as an organization. So build in that safety risk exception and define what that means in your policy. You still have a responsibility to protect your employees and your business at large. So not just the one impacted employee, but your entire company and all of the employees. So if you believe there is a threat that is realistic, possible, probable, reasonable, it's okay to take action. But in the other cases, if you're going to allow the party to make the decision, follow through with that. If law enforcement doesn't know, you can't expect them to help you. You can't expect to have access to community resources. Communities have a lot of resources, from victim advocates to crisis centers, to free crisis therapy, to state victim compensation funds. But if there isn't a report to law enforcement, none of those resources will be available. A lot of police departments have victim advocates working in the police department, employed by the department. You can go to them first. So that's one of the discussion points you can have, or one of the things that you can think about is, if we need help from outside, if this is too much for us to handle or the individual to handle, we may have to go to law enforcement to turn on all of those resources. And then again, they have a knowledge of crimes and patterns in your community that you don't have. You don't know what they have, and so they are not going to be able to add your statistics to better enforce and prevent criminal behavior if you don't share it with them. So all of that being said about reporting to them, if there is a concurrent case, there's a criminal case and there's an administrative case. They're different. They both have different purposes. The law enforcement's case is regarding a crime. Their penalties are greater. They can put someone in jail. Their case can lead to legally taking away someone's freedom. That's why they have higher standards that they have to follow, rules of evidence that they have to follow, constitutional requirements, statutory requirements. They have a much higher standard that they have to follow in their investigations because the penalties are much higher. Whereas in your case, which is an administrative case, you are investigating, to simplify it, you're investigating whether or not they broke a rule. Your misconduct policy is a set of rules or expectations, and you are investigating whether that rule was broken and then deciding what to do about it. You have a right to do that. You have a right to conduct an administrative investigation when someone in your business breaks or violates your policy. So don't let anyone tell you you don't. What that looks like could depend on employment law in your state, bargaining agreements, contracts, unions, that sort of thing. But you have a right to respond to misconduct in your organization. You also have a much lower standard. There's a lower standard of evidence. Instead of beyond a reasonable doubt, generally in an administrative case, it's preponderance. So that's very different. The preponderance standard is the same standard used in civil courts. The way that you collect evidence is less stringent. The evidence that you're allowed to consider, hearsay, etc., much less stringent. So you have some ability and capacity to look at things and to consider and analyze facts or information that law enforcement or the prosecutor doesn't. So that is definitely a pro. You're not bound by all of these rules, even though you still want to do a thorough and complete job. You still want to do it right, but it's different. So often when you have a concurrent case, you have to cooperate with law enforcement in some way. Sometimes it's because they need information from you. They need employee records. They need access to employee spaces, to your workspaces, to your production line or your offices. In order for them to be successful, they need access to records. Work with your general counsel, your attorney, and figure out how you're going to cooperate. Do you have a privacy policy in place involving your employees, involving your customers? Especially if you are an online business, you probably have a privacy policy to let your customers know how you are protecting their information online and their personal information. So all of that comes into play. And then decide in your cooperation with law enforcement, do you require subpoenas, and warrants to share information. Do you require it for anything or just certain information? If they're asking for personal identifiable information, then you require legal process, but anything up to that you don't. Where do you draw the line of when you require some sort of legal process? That's okay. It's important to cooperate with law enforcement. That makes life a lot easier, but that doesn't mean that you just give everything away. In fact, you shouldn't. It's actually better for them if they have to fill out some sort of paperwork to get records. It actually firms up their case. So if they have to write a warrant and get a judge to sign a warrant that that they have probable cause to search this location or have access to this information, that actually helps strengthen their case. It's a good thing. A lot of times they don't want to do it because it takes more time and it takes more effort, but that's part of their job. So you may get times where someone asks you on the side as a friend to give you information. If your policy is to require process, then say, I'm sorry, this is to protect me, this is to protect your business, also protect you. I need you to go ahead and write a warrant. Honestly, I've written a lot of warrants and they don't actually take that much time. The first couple, yes, they do, but you start to get good at it and know what you're doing. They're not that hard. And they're very important. They help the investigator really organize their facts and really know if they have enough information or if they need to go out and get more, if they have probable cause. It's a very valuable tool to utilize for everyone involved. So if that's your policy, then it's okay to enforce that. Follow your privacy policy, even if you're trying to make friends. Follow that privacy policy. Your customers expect it of you. How many times have you seen a news article of a data breach at a company and you find out that the privacy policy was weak or allowed for this data breach to happen? And suddenly the company is scrambling. A lot of times there's a settlement that costs them millions of dollars because they did not have a strong policy or didn't follow their privacy policy. Your customers, your clients expect you to keep their information private. So there is a balance of maintaining information private, but also cooperating and providing it when needed. It's also a balance between privacy and speed. Legal process does take longer. It does take time, even though it's not quite as difficult as they'll try to tell you it is. It does still take time. It takes time to write. It takes time to talk to the judge. It all takes time. So that is a balance, privacy versus speed. Look at the case, the details, what's happening. If it slows down the investigation a little bit, it may increase the intrusion time of law enforcement. So it may increase the amount of time that you have to spend working with them, talking with them, having them in your office spaces. So the child pornography example, you call, they start preparing a warrant to come in and look at your network and stuff. But in the meantime, they are going to ask you to pull the hard drive, shut down wherever the impacted area was on your network. So that is shut down. No work is happening on that computer. No work is happening in that sector while that is shut down. And it takes time for them to get the information they need to write the warrant, to get the warrant signed, to come in and serve the warrant. So you aren't producing anything during that time period. And then they may have to seize the hard drive, or they'll copy it, they'll make a forensic copy on site, and then you have to wipe it. Most likely there's a lot of different ways to handle it. The bottom line is it is going to take time. It will disrupt your business. In the long run, that's okay. That's a good thing. You want to handle that. You don't want that on your network. you want to get rid of it, you want to take care of it. It's just something to consider. Because you need to cooperate, is your investigator the person who is your go-between? Is your investigator comfortable speaking with and working with law enforcement officers? When I was working administrative cases, I was totally comfortable with it because I was one. I could speak their language. I understood what they were talking about. I understood what they were going through. They couldn't get anything by me, if to put it that way, because I knew their requirements. I knew what they were doing, what they had to do, what came next. So I was very comfortable engaging with them. Your investigator may not be. I would encourage you to build that trust and build that ability, because your investigator is going to be the most effective person to talk to law enforcement, because your investigator is actually the one on the ground doing the work and understanding the case. If your investigator is not comfortable with it, you may want to assign someone in your general counsel's office or your administrator to be involved, to be the go-between with law enforcement. They have requirements. They have authority. They're carrying the badge. They have the statutory authority, but they also have requirements. And it is important for you to understand what those requirements are and what those boundaries are, so you know what they're asking for and why, and what they can and can't have, etc. And I'm not saying that they're going to try to take advantage of you, but you need to be on the same page where you understand where they're at. Don't be bullied by law enforcement. I'm going to talk about that more later, but I bring it up twice for good reason. You have a right to work your case. If law enforcement refuses to talk to you, they try to tell you that you don't have a right to work this, you don't have, you need to butt out. It's okay to push that up to your attorneys and just have it between their supervisor and your attorney. Try to keep the relationship between the investigators as strong as possible. You want to build that relationship. So if there are issues, if there are disputes or problems, push those up to supervisors, attorneys, so that you're not destroying the relationship of the investigators on the ground. You want to try to handle it at the lowest level possible, but if it's not being handled, if it's just not working out, don't destroy a relationship that you need in the future, because odds are you're going to have future cases with that detective, with that squad. So you want to build that relationship. Consider having one point of contact for law enforcement, and that often is the general counsel's office. It could be your investigator. Publish it, make it easy to find. I don't know how many times, how many hours I've lost trying to figure out who to send a subpoena to. When I was in law enforcement, I would get a subpoena or get a warrant, and I need to serve it on a company to get records or information, and it takes hours to figure out who to send it to. And then when I do finally find it, it's a fax number. It's very little information. There's no person. There's no actual point of contact. So that's also a big delay. Just figuring out who to give it to for law enforcement is really tough. So a lot of companies have gone to where they have a link at the bottom of their webpage, for law enforcement inquiries or something, and it pulls up a page, and there's an actual person that they can contact with an email address, a phone number. And so it's very easy and quick to find. I had documents where people tried to compile lists of, here's all the point of contacts for all the businesses, and you refer to those, and then you would call that number and it was out of service because it was too old, or you would try to send a fax and they didn't use faxes anymore. They wanted an email now. So the best up-to-date information, that's your responsibility to provide it, and that will speed up the process. That will allow them to find the person, and then when you have one point of contact, that point of contact starts building relationships and starts kind of understanding the process and how things are going to work. You can put that person wherever you want. Security, in your security department, your misconduct investigator, your attorney, someone in human resources. It doesn't really matter. It just needs to be someone who is able to talk to law enforcement, is comfortable talking to law enforcement, and it is able to provide the answers to the questions that they have or the information that they need. So they need to have some knowledge. You can actually coordinate your administrative case with the criminal case so that you're both successful. You can both have a successful investigation. You may not be able to share information, but you can coordinate investigative actions. So what I mean by that is, in an administrative case, very often you will talk to the respondent up front. In Title IX cases, that was a requirement. As soon as you initiated an investigation, we had to notify the respondent that they were under investigation. That is true for most administrative situations. In a law enforcement case, they can investigate for months, if not years, before the suspect even finds out they're being investigated. So in a law enforcement case, you generally get the evidence first and then do the interrogation. So you want to coordinate that timing. If you are planning to go to the respondent and tell them all of this information, that all of these things that are alleged to have happened or that this person has done, maybe you want to coordinate with the detective to say, hey, I need to talk to this person by my policy, but I don't want to ruin your chance to talk to them. Can we coordinate timing on this one? If you're close, if you're going to do this here pretty quickly, I can wait until you're done. That type of thing. Or collection of evidence. They have the right to actually seize the physical evidence, but maybe you need pictures of it, and that would be helpful. You can coordinate that. Maybe you have evidence. One of the parties provided you evidence, and so you have it sitting and they need it. So you can coordinate turning that over and describing how you had custody of it. You may choose to share statements. When you find out and they come to you and say, hey, we hear you've been talking to witnesses and stuff, can we have a copy of those statements? You may choose to share those, you may not. That's between you and your legal team and your policy, your privacy policy. But that's something that you have to consider. So there's a lot of stuff that you can coordinate without sharing information, without giving away details, that will help you both do your job, be successful, that will kind of bridge that gap between the two cases. But don't expect them to share their information with you, especially during an ongoing case. They may ask for your statements, but if you ask them for theirs, you're not getting them. Later, under public records laws, you may get access to redacted copies of them, but you will probably have to go through the same process as the press or any other member of the public has to go through in requesting those records. And every state has a different process for that. So just recognize up front that sharing is a one-way street. You may share with them, you may decide to, legally you may be able to, but they are not going to share their results back with you. And that's okay. You can still be successful. Original evidence, physical evidence, that belongs to law enforcement. You can't keep that away from them. So if you have to take pictures of it, take pictures of it. Whatever you need to do that won't destroy or alter their evidence. If you went through and looked through a phone and then you find out later that there's a criminal case and they want that phone, be open with what you did with it. Hopefully you documented it, and you should have documented your steps. You should have documented when you got the phone, when you looked at it, what you looked at, and the date and time when you started looking through it. Provide that to them so that when their forensic examiner goes through, and says, well, all of these were accessed on this date, they know that it was you and not the suspect of their case. It's okay to have pictures of it. It's okay to take copies. And it's okay if it was provided to you first, especially if you didn't know there was a law enforcement case. Just be prepared and ready to hand that over if they ask for it, whether you need a warrant or you're just willing to hand it over. I've heard a lot of people say, well, why don't we just wait for the criminal case to finish? Law enforcement officers are much more capable. They are trained. They are the people that should be conducting these investigations, so we'll just let them do it. That was a big argument against Title IX cases, was that universities shouldn't be in the business of investigating rapes. Well, that argument could be applied to any kind of misconduct, because most misconduct is also a crime. You have a right to investigate misconduct that happens in your organization. You have a responsibility to do it correctly, to pursue and receive the training so that you are doing it professionally. There's no excuse for not doing it correctly, but you still have a right to do it. And if you're thinking, well, let's just wait for the criminal process, that can take years. So are you prepared to have your respondent continue working for you, given the alleged behavior, for years before you make a decision? Because that's how long it's going to be before the case has gone through the court system and you can get access to the reports. Business moves at a much faster pace than government. So I would venture to guess that you can't wait for a criminal case to be done. Maybe there are instances where it makes sense. We had a Title IX case where it did make sense, and the student actually agreed with it, and that was important. The student agreed and actually stepped away from school to focus on the criminal case, to focus on his criminal defense. And so it worked for the university because the student wasn't actually attending classes. He was focusing on the criminal case. Once that was done, we opened our administrative investigation. And at that point, we did have access to some of the information from the criminal case, which helped. If in this instance, it actually had a big impact on the outcome. But that only worked because the student agreed to take time off from school during that time period. Usually it doesn't work. That was an exception. So you can talk about that in your policy if you want to. I think it's more of a practice thing. It's not necessarily a policy-driven decision, but it can be. If it's something you believe you will do on a regular basis or that you are going to seriously consider in a lot of cases, then you probably will want to include it in your policy. If it's going to be the very rare instance, it's more of a practice thing, and all involved should be in agreement, and that should be documented. That was also very important that it was documented, the conversations between the university and the student. If you have this good relationship with law enforcement, that'll help you know when you can proceed. You don't want to screw up their case. You don't want your administrative case to screw up a criminal case. So someone gets away with a crime, doesn't go to jail because of something you did. If you have a good relationship, open line of communication, you can prevent that. You can have that conversation. Hey, I understand you're working your administrative case right now. We actually have an upcoming operation this week. We've got some stuff planned. So could you hold off until next week doing anything? Sure, roger that. that one little phone call has a very large impact on the case. But that phone call is not going to happen if you don't have a relationship. Instead, there will be no phone call. You won't know. You'll move ahead, and then everyone will be angry that you screwed up their operation, and you're sitting there going, well, I had no idea what was happening. How can I screw something up that I don't even know is happening? We talked a little bit about providing your statements and file, and you may choose to do that. But just remember, your entire case file may just be subpoenaed. Instead of asking for it, they may just straight subpoena your entire file. That's another reason to make sure that your file is thorough, that you have a good investigative plan, you've documented everything that you've done, and that they can look at your file and see that you know what you're doing. You are trained, you have experience, and you're doing a good job. You might have things that they can't use. You're not bound by Miranda. You don't have to read or respond to their rights under the Constitution. You may have something you have to inform them of with their contract or bargaining agreement or something, but as far as their Miranda rights, you don't have that requirement. You don't have other constitutional rights that you had to abide by. But the more you ensure there's equity in your cases, the more that you ensure that you are giving them what would be considered due process in the courts, the more professional your case file looks, the more professional your investigation looks, the more it looks like you know what you're doing. That case file is going to be looked at and judged by the detectives and law enforcement, the prosecutors, and potentially a jury and a judge. And all of those people are going to be judging how well you did, what kind of investigator you are. So you're no longer just the little investigator from this company. You are now being judged as a professional investigator by professionals, other professionals in the field. So if your case file is solid and thorough, that will engender trust that you know what you're doing, which will promote your relationship, promote future cooperation. A detective is much more likely to call and cooperate with someone that they trust in and know when they know what they're talking about. That was one advantage for me as I got to know law enforcement in the area, is they recognized that I could speak their language and I knew what they were talking about. I was experienced. I knew what I was doing. And your work product is how you build that. That's what they see. You need to learn the criminal process. You need to know. You don't have to go to a police academy. You don't have to be post-certified, but you need to understand their process. You need to understand what they're doing. You need to try to understand their point of view so that you can speak their language and cooperate with them. It also gives you the ability to answer your employees' questions, help them make informed decisions when they are considering or wondering. Know your policy, know what you will do, know what you're able to do, and what you're not able to do. And also know what law enforcement can and can't do. So here it is again, don't be bullied. So I had an investigation where it was an administrative case, a student. She came to me with allegations of sexual assault, a pretty brutal, violent sexual assault. At the time she came to me and requested the administrative investigation, she had not gone to law enforcement and was actually leaning towards not reporting to law enforcement. So what I always did is I always said, okay, well, if you ever go to law enforcement, please let me know so that I can coordinate with them. Just give me a heads up that you've made that decision. Totally fine if you do, not a problem. And in fact, I can talk to you about what that'll look like. It's just very helpful for them and for me if I know. She ended up going to law enforcement, and I was not aware of it. And that's okay. I don't blame her, but I didn't get the message. So as part of my requirements, I reached out to the respondent and provided him with the allegations. And then I got an angry phone call from the investigating detective sergeant claiming I had ruined his case and destroyed it, and now there's nothing he can do about it because his suspect now knows everything, and his interrogation went out the window. He was very upset. And so I had to talk to him and say, listen, I couldn't not do something I didn't know, and I have requirements, and through Title IX, there are federal requirements that I had to follow up on. So if you had called me and told me that she came to you knowing that she was a student, we could have worked something out. But not only, she didn't come to me, and then you have a phone and could have called me and didn't. And he was getting very upset, and he started saying, that's obstruction of justice. I'm taking this to the prosecutor, and I'm going to charge you with obstruction of justice. So that's one of those, whenever someone's not cooperating with law enforcement, that's the threat, right? It's an actual crime. It happens. It can be prosecuted, but it's something that is sometimes used to throw weight around. And so he was used to people being scared of that, like responding to that with fear that someone in authority is going to charge me. But because I knew what he was talking about, I'd been in his shoes. In fact, I'd actually been in a position where someone else had influenced a case unknowingly. I was able to say, that's not obstruction. Don't threaten me. That's not even close to obstruction. So according to federal law, obstruction is an act that corruptly or by threats or force or by any threatening letter or communication influences, obstructs, or impedes or endeavors to influence, obstruct, or impede the due administration of justice. So clearly what I did didn't fit that at all. The state statute is a little bit different, but it's still the same thing. There was no intent to obstruct. There was no intent to interfere. In fact, I didn't interfere. I was conducting my case, and the fact that it negatively impacted his case wasn't interference. It was just unfortunate. Interference would have been, if I had talked to the respondent and told him what to say to law enforcement or influenced, going down that path. So I was able to say, don't threaten me with that. That's not obstruction. Instead, I know you're angry. I apologize. It wouldn't have happened this way had I known. Let's figure out in the future how to avoid the situation. This one has already happened. Let's figure out what to do in the future to avoid it. And that's where we came up with a system of cooperating where I would reiterate with my students that if they go to law enforcement, they need to contact me. And he would train his detectives that if they had a case involving a student, that they could call and let us know, or they could ask the student if it was okay to share information. So they would get permission from the student to call our Title IX office to say, hey, we have a case with this student, so if you do too, let's talk. And we were able to do it in such a way that we weren't violating any privacy laws. FERPA, we got permission for everything that we shared, but we were able to coordinate our activities so that my actions wouldn't negatively impact his and vice versa. And in fact, what happened in the future, we would go to these working groups or task forces in our area that involved special victims crimes. And we would attend these so that we could meet people, so that they could see us, even though we were kind of on the fringe because it was all law enforcement and prosecutors, all state officials, and we were private. it was helpful to them. They could ask us questions. And in fact, we presented at one of their meetings on our process and what we do and how willing we were to work with them and to cooperate with them and ensure that both processes were successful. Other things you can do is get involved in their world, volunteer in community justice efforts. There are abuse shelters, there are child advocacy centers, there are rape crisis centers. Get to know those people so that they trust you and they know that you are capable and professional. You may not deal with them very often. In a Title IX setting where you're working with sexual misconduct, it's a very frequent thing. You may not be doing it very often, but when you do have a case, these relationships will be invaluable to you. If you get to know the detectives, even informally, they know that you are the company, you are the investigator at ABC company, and they get to know you and trust you and like you and trust that you are professionally competent. All of that is going to help that relationship, which will engender or help cooperation, and that leads to success for both of you. I would advise you to share what you can, because that is also helping to build your relationship within your privacy guidelines, with attorney approval, all of that. But if there's something that you can share, that you're comfortable sharing, that gift will go a long way. You're constantly being judged by your actions, by your professionalism, by your documentation, by your knowledge of the system and the process. And so it is imperative that you become knowledgeable. You want them to look at your case file and say, wow, this investigator knows what they're doing. We will work with this person in the future. No problem. No hesitation. That's your goal. Both cases can be run concurrently. I've done it multiple times. I've seen it done multiple times. I've had cases where the criminal case they weren't able to pursue, and yet my administrative case, I was able to have a finding because I have access to different information and I have different standards. So there are times where even if the criminal case is not successful, you can still be successful in your administrative case. So don't give up. If you have, I remember a time when I got a case and I coordinated with the detective on the timing, and the detective got back to me and said, yeah, this isn't going anywhere. We're not filing any charges. There's nothing to it. And so then I dived into it using my resources, my experience, what I had at my disposal, and I was able to find plenty of evidence for a finding. So don't be discouraged if there's a criminal case or if they tell you that you don't know what you're doing. You can still be successful. You can still do a good job. You can still uncover evidence independently that is very useful to your case. Coordinate as much as you can. Communicate, open those lines of communication. Make sure they know who to call. They know who you are. They've seen your face. They've talked to you. They see you as a person that they trust. And your coordination, your communication will just increase, which will help your cases. All right, so next, the ebook Tips for Leaders in Preparing for Misconduct is still the book you should be working through those exercises and reading through the book. So continue reading that. If you are taking this lesson as part of a course, you will have been sent the book as part of the course. If not, if you're taking this lesson independently, you can go to my website and subscribe to get the book free, or through the store you can purchase. Again, if you're going through as part of the course, there is a quiz for lesson 6, and always check out our YouTube channel for supplemental lesson videos. Our next lesson, we are going to talk about appeals. So how to write an appeal process into your policy, the pros and cons, if you do, what it should or should not look like. So don't miss out on lesson 7. At the Williams Consulting Group, our goal is to help you protect what is valuable to you, and we do that through personalized consulting with your organization and through our training academy. So if you have questions, if you need help on a case or building your policy, building your process, let us know. We can provide training materials or personalized support to you to help you. And that's protecting your business, that's protecting your employees, your families, your customers, everything that is valuable to you and making you successful in your organization.